Anyway, here we go. Welcome to another episode of Working Class. I'm your host, Attorney Ryan. I am joined by one of my good friends.
Wait, everyone time the book out. I gotta get situated.
We're going to keep
Hannah
that
knows.
in.
I'm like, wait, what do I look like?
Because I don't think that characterizes Reb any better way
Oh,
than an
it's
intro
this.
could.
I was like, what is this?
There
It's
we
this
go.
thing? I thought it was my hair. Okay. Now you can totally do what you need to do.
Okay, do I have permission to continue, counselor?
I don't know. I don't know how it's gonna be. I'm gonna be like, hello. You know how? Wait. Have you seen the movie? Fuck. I'm gonna say this last thing, then we'll keep starting. Have you seen the movie Four Christmases when Vince Vaughn? He's super charismatic, really funny, very Vince Vaughn, and like the bit is that the moment that a camera gets in front of him, he just goes,
Yeah.
like he's like, like imagine if I did that and you were like, okay, period. Thank you so much. Like you were a perfect guest.
So, real talk, breaking the fourth wall. Our prior guest today had the same problem.
Okay,
I encourage
fuck.
you to. I'm
I
over
usually
here.
don't.
No,
I know you are, but I'm like, this camera, I don't want to be like,
Don't worry about that.
okay.
Secondary. Just have a conversation with me.
Okay,
I'm
perfect.
right here. We're literally just gonna talk
Amazing
shit.
perf.
We're gonna be right here talking shit.
Amazing stunning.
Okay.
Okay, I'm ready.
Do I have permission to start my show now?
One, two, go. You totally do. You totally do.
We might leave that in because that was kind of funny. But
I'm stressed.
Reb.
I can't look at myself. Okay, go.
right here. Look at me. Right
I'm
here.
ready.
This is home.
I'm
right
ready.
here. You just stop looking over there. Ignore that. We're gonna put a towel over it in a minute here. You understand?
Go.
You can't
Okay,
handle
I'm
the
ready.
responsibility.
Okay, I'm ready.
Okay.
I'm so ready.
We might leave that in because that was chaos.
Okay, cool.
But it was a cool kind of chaos.
Okay, amazing.
I'm going to do a quick intro just in case. Welcome to
amazing.
another episode of Working Class. I'm Attorney Ryan. I'm coming fresh off an incident in the studio. We may put that in. I don't know what we're going to do with it. But I'm
hope
joined
so.
by my good friend, almost a year exactly, to the first appearance that she was on.
Mm-hmm.
You might know her as Reb Masel. She is the host of the Rebuttal podcast, a really awesome series, true crime, great stuff. I listen to it when I work out. You should listen to it too. Also claim to fame reading sassy court transcripts. But what I love about you, Reb, is as time has gone on, you use your platform to talk about issues you care about, and you break down complicated issues of law in a way that people can understand, that's also sassy and speaks truth to power, which is why you're one of my favorite people. You're brave as fuck. So thank you for being here.
Right back at you. Thank you very much. I
thanks, buddy.
love coming here the first time, and I'm happy to be back.
Yeah.
Truly.
Thanks for joining. No, I wanted to bring you back here today because we had, how do I describe this most recent Supreme Court term? As a workers' rights attorney, I would call it a dumpster fire.
Mm-hmm.
As a civil rights advocate, I would call it a clusterfuck.
Mm-hmm.
And as someone who doesn't want to live in a dictatorship, I'd call it a full-scale crisis. But
A cash
perhaps
grab.
a cash grab
A
is
power
good
grab
too.
and a cash grab, but the cash grab is specifically for 6 particular people in the United States of A. I would pause that. I would say there are very obviously 6 people on the court who have their pockets very much filled, very much kept busy by PACs, by very powerful, rich, clearly rich people. The corruption and the financial motivations of 6 of those justices, at least 2 of them has been, thrown onto the national stage. We've seen it. It's evidence. It's not me speculating. It's not a conspiracy theory. If you just Google Justice Thomas, cash grab, Justice Thomas, financial bribes, you will see documented evidence and him basically saying, yeah, that happened, and nothing has come of it. And then all of these opinions were, yes, it's shocking as an attorney to see this term be what it was, just because the status quo of so many things that have been established precedent for so long for a reason through conservative, quote unquote, and liberal courts who have, regardless of their political motivations, understood the value of precedent and stare decisis. To see it be shattered so clearly, unabashedly, and without even any resolve to try to rationalize it with proper statutory interpretation and the application of constitutional text or the application of reasonableness is just, it's offensive. As a lawyer, it's offensive because you just think, despite how much I talk about the corruption of that permeates our field, we cannot continue on as lawyers without some kind of hope in the integrity of the field.
Yeah. And it's
And it's
certainly
gone.
concerning when we talk about the integrity of the field. It's you don't get to just go into court and say whatever you want. If you're going to present an issue of fact, you should have proof of that fact. If you're going to say, hey, I think this sidewalk my client tripped on was unsafe, you should bring in an expert, preferably an engineer, someone to say what this sidewalk should have looked like.
Right.
You don't want the judge just deciding if the sidewalk's safe based on vibes, or worse, based on who they went yachting with that weekend.
And the foundation of lawyering, the foundation of being a judge, most importantly, is humility, which sounds like something most people, regular people would not connect with the lawyering field or the judge field. But truly, anytime lawyers don't know something, which is every single day of our lives, our jobs aren't to know everything. Our jobs are to research it and learn it or find someone who can. That's why we put experts on the stand. We don't put ourselves on the stand to tell you about blood spatter. Judges do not issue opinions, especially higher court judges, specifically appellate justices, federal and state bench, and the Supreme Court historically for however many years, in footnote after footnote, they cite to historical text or precedent or scientific studies. They cite to law review articles that have done the footwork and have done the research on social issues. They cite to percentages. They cite to statistics. They look at amicus briefs that are filed by nonprofit agencies that do this work for a living, or by environmental protection groups that say, hi, we've done here's the raw data. Your judgment needs to be right. Needs to at least take this into account. It doesn't mean that the courts have ever been run, I don't think, by, lobbyists necessarily, or by these amicus briefs, right? It just means that judges have to toe the line between being a judge and doing what lawyering is, which is applying, the rule of law to the facts, and also taking into account that they're not going to know everything about the facts first.
And that becomes an issue when you have a judge who maybe doesn't care about the facts. Maybe
Not
they've
even a
already
little.
decided how they want the case to be decided long before it's come before them. And they are just waiting. We call this an activist judge, by the way. An activist judge is one who is just waiting for the right plaintiff with the right argument to come before them so that they can rule the way they want.
And this is what this court, the Supreme Court, is they are an outcome-fueled court. They are not a case-by-case court.
I want to pause right there because that's really important. What do you mean when you say outcome-fueled court?
The court isn't caring about the public policy perspective of a specific case or the facts of a specific case. They're not worried about the ramifications of the constitutional interpretation that they're handing down or the rule that they're handing down for all of these other lower courts to have to apply later. All they want is for this specific case, whatever it may be, end up ruling something that they like. A political issue, for example, abortion, gun rights, environmental protection, employment rights, workers' rights, unions, anything like that, presidential immunity. All they care about is that it's either going to be a yes or a no. However they get there, they are going to bastardize an analysis to essentially basically try to justify that their conclusion is correct. But proper judges, even if they think that the conclusion politically or personally is wrong, if they know that the right answer, based on precedent, based on the constitutional text, based on the sound principles of law, they get there anyway. And we've seen it. That's the thing, is that people, what annoys me the most is when people do the whole, of course, people, judges, lawyers can never be entirely apolitical. They just can't, because there's always going to be bias there.
You're always going to have a bias.
Right. But what people don't see, because it would take 3 years of law school and practicing law to see, is the big picture of the Supreme Court and the big picture of a lot of very famous circuit justices, judges, and appellate judges. Is there have been so many examples, and I remember several of my professors would have us note it, that when a justice broke off from
goes
their
rogue.
Right.
Yeah.
They not even, go rogue, but like they broke off from the political affiliation of what people thought they would do, because they would even drop a footnote sometimes and, explain it and say, I don't believe, I don't like this ending, right? If they're a very liberal person and the outcome that they, that this case was wasn't what they necessarily wanted politically, but they had to do it because it was jurisdictional, because it was a mootness issue, because, constitutionally they just can't, they don't have the power to do this. It's not for us to decide, it's for Congress, or if it's not for us to do or enforce, it's for the executive. That has happened so many times where it had, I'm not just blindly thinking, oh, this field has integrity. It did. But now when 9 people are throwing it to the wind, something needs to be done.
Something does.
Yeah.
There's been a cry. It was a battle cry on the right wing for a long time, and it suddenly died down. This notion of the activist judge or legislating from the bench. What does that mean to you? And is it a good thing, a bad thing? Why would people be so upset about a judge effectively writing rules from their courtroom?
Well, in my opinion, and I mean, it's not even an opinion, it's just a fact, what you learn immediately, which is most things that I say. Every opinion I have is just fact.
Everything Reb says, we're taking judicial notice.
Thank you very much. What people don't understand is they think that the rules that we live and die by day to day are all rules that were written by a politician in a room somewhere and passed by, a popular vote. Most rules are judge-made. Most rules that we live by day to day are judge-made. So many right? Like constitutional rights, criminal rights. I mean,
there's a balance. Sometimes that's okay.
Right, and sometimes that's fine.
Sometimes Congress anticipates that.
Often, and that's what Chevron is, right? It's not, and to say that people immediately think, oh, that's horrible. It has worked, and you understand why judge-made rules last and why judge-made rules and precedent make sense is because politicians always have an angle, and politicians always do things that are unconstitutional. They pass things they know are unconstitutional, knowing that the courts are going to overturn it. It'll be fine, right? They're just trying to get reelected. When you have judges in place, and I'm talking about like district court judges, any kind of judges, not just the Supreme Court, are making rules all the time. They have built a body of law that is, yes, intertwined with what Congress passes for statute, but it's very much one that has to rely on itself to be reasonable and to apply things properly and to, make sure that we have stability and uniformity in the way that we interpret law with how society changes and with how movements change, with what the public wants and needs. I mean, you see Obergefell, right? Gay rights passed. Yeah. The reason why same-sex marriage was legalized was not because they bastardized the process and made the analysis insane and they pulled it out of nowhere just to push a political agenda. They reasoned, I think, fantastically. Yeah, some people say, oh, well, that opinion could have been better written. Okay, but every opinion probably could. Most can. But it wasn't, you can't argue that Obergefell was pulled out of nowhere. It's a foundational equal protection, right? It's foundational procedural substantive due process rights that are implicated and that fall under a line of other cases like Loving versus Virginia.
I was about to say Loving. There's been a long,
Virginia.
Steady march to the decision that, hey, gay people are people and they can get married and they can love each other and it's not a threat to you.
And Loving versus Virginia, for those who don't know, is the Supreme Court case which legalized interracial marriage. I was like, subsidized marriage.
That's not subsidized.
Yes, interracial marriage, right?
No
interracial marriage, yes. Yeah. Interracial marriage. So, the line of cases that Obergefell was following, it just got in line. And it wasn't, they weren't creating a new line. They weren't throwing the rug out from under an entire line and saying, you don't exist anymore. Because, right, when you have several different Supreme Courts before you deciding the same type of thing, you falling in line with that makes sense. And it's best for our foundation of law and our system as a whole, because you want and we need stability. No matter what happens in the world, in the country, we want to be able to say that if a movement happens, if something happened, if something shifts, that something else can fall into line, right? We get to look at what we've done before, not just like founding father types. Okay, no. What we've done before, like the 80s and the 90s and the 2000s judges, okay, right? Yeah. And for the most part, with some exceptions, even though justices have, of course, always been politically appointed by a Republican nominee or a Republican president or a Democratic president, they always, after a few years that studies have been done on this, if you look at their opinions, the opinions they've written, whether they've been concurring opinions or dissenting opinions, over time, they fall into the middle. And there's a graph about it, about all of these different justices, because they don't have to fight for re-election. That was the whole point of the life term situation that's now up for debate, because you want someone who doesn't have to please anybody or be bribed by anybody. But now, okay, the fact that these justices, especially with this term, I think it's the biggest power grab that they've had yet. The biggest power grab that the Supreme Court has seen, I think, since like 1805.
Yeah.
And it's just so blatant.
Are you making a Marbury v. Madison reference?
I think so, yeah.
Yeah. There's been some debate about how serious this was. I want to hear you finish your thought, but I did want to quickly present what the picture you're painting is there was a time, and look, there's always been money in politics.
Always.
There's always been, hey, you go to the right golf clubs, you might bump into a judge and maybe get a favor. That's always existed. But the shift we're seeing is, hey, a Republican appointed this judge, but this judge isn't going to ignore precedent to say, all right, abortions are illegal in all cases and everyone gets an AR-15 when they're born and you have to keep it. Like that's not what happens. You see something kind of falls to the middle.
Right.
But what we're starting to see with hashtag Sugar Baby Thomas, for example, is we see judges who are being appointed based on recommendations from committees who are funded entirely by extremely wealthy interests who do not give a flying fuck about the general welfare or even the stability of the country.
Mm-hmm.
They have motivations that are entirely selfish. And so a great example of that would be what happened in Loper Bright. And for those who don't know, you saw the headlines, you saw, okay, Chevron overturned. There were a few different sub-headlines to that, depending on what kind of media you subscribe to. One form of media said, horrible, unelected bureaucrats ruining the world and making your guns illegal finally get a slap to the face. Congress now has to actually do their job and write clear laws. Now we have justice. That's the right-wing talking point. But then workers' rights lawyers like me are saying, what the actual fuck? Most of the rules I enforce that make it able for me to say, hey, if your boss steals from you, I can get your money back. Hey, if you are in a warehouse and it's so hot your friends are fainting, we can get an order for them to fix that for you. That is now in jeopardy because of Loper Bright. And it was not done. I want to be very clear to people who are listening. The justices who overturned Chevron did it because they are buddies with billionaires who don't want to be regulated. They are buddies with billionaires who want judges to have as much power as possible. We talk about this power grab. It empowers the judiciary to affect the will of a billionaire donor. I don't think this is a conspiracy theory because we have pictures. We have videos of these guys on yachting trips with these people. And if you read the opinions, and I know Reb has some here with us today, they are hot flaming garbage word salad. They are not well-written opinions. They are mental gymnastics performed by judges who want to make sure that they have the authority to affect a billionaire's will while getting paid. Why does this matter to me so much? I understand a lot of right-wing people hate the ATF. I get it. You don't want a bunch of, quote, unelected bureaucrats telling you how many bullets you can hold in a magazine. I get the frustration. Not all bureaucracies are going to do things you like. But at the same time, OSHA is the reason you come home alive after work. And we have a justice in the Supreme Court right now, Sugar Baby Thomas, hashtag Sugar Baby Thomas, who has said many times that he does not think OSHA should exist. He says that he thinks it's constitutional overreach, but really, I'm pretty sure his billionaire buddies just don't like OSHA and they don't like those regulations. So we now have a dangerous situation where with Chevron overturned, the power of a lot of these federal agencies that keep you safe, well, a lot of their rules are now up for debate, whether they even had authority to pass them. So with that in mind, I really want to kick it over to Reb. And just, can you tell us what the hell happened with Chevron? What is the case and why are people like, I'm sweating. Why am I sweating?
You don't have, I mean, you can like take a break, like.
I think I'm just upset.
Oh, you're sweating. I'm like, oh, okay.
No, I'm upset about Chevron.
Like
well, Loper Bright is what I'm upset about. That's really the case. Long story short, because I don't want to burn too much time on it. Basically, that was a case where some commercial fishers or anglers, whatever you call them, were being regulated on herring populations. And the rule was if you're going to go out and fish, you have to pay to have an observer basically with you. And there was ambiguity in that statute, whether, who pays for it. So the commercial fisheries challenged that rule, saying we don't want to pay, I think it was like $700 a day, for a federal regulator to sit on our boat and make sure we're not bringing in too much herring. That made its way to the Supreme Court, and every lawyer worth their salt probably didn't even pay much attention to that because, well, Chevron deference. If the experts say, hey, look, we've examined all the facts of this, we have to keep herring population stable because if that population collapses, albacore, tuna, and all these other species we depend on, they'll be jeopardized. So if you want to fish in these resources, you should pay something of an entrance fee in the way of an inspector or a regulator to make sure that you're taking safe amounts from the ocean. Well, that's not particularly good for some commercial businesses' bottom lines. And it really wasn't about the fish. I want to be very clear about this. This was not about fish. This wasn't about protecting a small business. This was really, in a way, about the EPA. This was really, in a way, about the National Labor Relations Board. Because what the Supreme Court did that was so sneaky is they got the sort of right-wing voting people, everyday working class people, to say, hey, I like small business, and I don't like when the government hurts small business. I'm Attorney Ryan, and I agree with that message. But I only agree with that message when it's true. What happened in Loper Bright was the Supreme Court found an opportunity to undercut every regulatory agency that prevents corporations from putting their stock price ahead of your basic safety, ahead of your paycheck. And they dealt it a body blow. Mm-hmm. So every
regulatory agency that keeps our government up and running, that keeps our lives up and running, the FDA, the NLRB, the EPA, I mean, the neutral ones, the progressive ones, the even conservative ones, like there are regulatory
agencies.
Who needs
safe drinking water?
Right.
Stock price must go up,
who
right?
really needs drugs to be regulated in a certain way? I mean, of course, I'm going to basically trust Nancy Pelosi to write a law that accounts for every single different type of drug that could be safe and not safe because she's an expert, right?
Sarcasm,
She's
by the
an
way.
expert.
Yeah.
Basically, it has been known and it has been well known for years that Justice Thomas, Justice Alito, and then Gorsuch as well, and the other conservative justices have hated Chevron. They've hated Chevron. And what Chevron is basically a Supreme Court decision that was issued in the 80s. And the facts of the Supreme Court decision originally, they might matter. It doesn't matter right now. It's too much to go through. But what it basically set for the last 40 years and have been adhered to for the last 40 years through every Supreme Court, okay, that's upheld it. And not only upheld it, cited to it, okay? Federal court cited to it. Over 14,000 times federal courts have cited to Chevron in the last 40 years in order to make decisions that implicate agency regulation, agency actions, okay? Because of course, so many different times, people or private actors or companies or whoever will sue over regulations or over fines or over anything. I mean, even to the extent that like Fish and Wildlife works, right? About what's a dam and what's a river, that type of stuff. Anytime Congress, that's the thing too. All of these conservative politicians have basically, indoctrinated into so many working class people's minds that Chevron and the idea of agency regulation is somehow some kind of overreach. Like, oh no, Congress should be doing this job, not an agency. Congress is the one who actually gives the agencies those power. That power, they write into their statutes, hey, so the EPA, right? Hey, so these executive agencies should, right, be the ones because they have to enforce these laws. What happens is that Congress makes very ambiguous, sloppy statute text frameworks, okay?
Quick pause with the ambiguous statutes, because there was a big talking point like, yeah, we don't want lazy Congress writing ambiguous laws. But I want to point out,
they will always be lazy and always write ambiguous, and they have written ambiguous laws for the last 40 fucking years, pardon my French, because they are accounting for Chevron. Everyone thinks that Supreme Court decisions are issued in a vacuum, and they're not. Congress, for politicians, and agencies for the last 40 years, companies have moved for the last 40 years knowing that Chevron was there. Whether they thought it was good or not, politicians knew that they could rely on it to not be hyper-specific, to throw the entire regulatory scheme and all of those statutes into limbo and into uncertainty. Because again, the the Supreme Court wants all of the stability that we've created to be gone and not left with stability that's just conservative. It's left with fuck. It's left with clusters.
And that's the important thing. It is clusters, because what's happened is when Congress writes those ambiguous rules, they're relying on experts in the field to fill out the details. For example, if Congress says, hey, we're going to pass a statute that says we want to keep herring populations stable, Nancy Pelosi probably doesn't know a herring from a sardine. I certainly don't.
No.
I don't know what they eat. I don't know what temperature of water they needed. I don't know, do they lay eggs? I don't know how they operate.
Right.
But you know what? There's a lot of scientists and biologists who work at these federal agencies because, by the way, they're not like deep state conspiratorial people. These are people who went up through college and their dream was to go work for the Department of Fish and Game because they just love the outdoors and they like being a scientist. Congress anticipates that scientists will figure out the best way to keep herring populations stable.
Right. The people who aren't politicians, who don't have their pockets filled out by PACs. Politicians can have that stuff happen for sure.
1,000%.
But what Chevron did for 40 years and the way, and people always assume, oh, okay, well, what was the process then if someone sued? Well, what Chevron would do, okay, knowing and accounting for the possibility that agencies could absolutely go fucking AWOL. For sure. Okay. We're not just giving them unfeathered power.
Oh yeah. They would,
right. Yeah. People always also assume, well, all these regulatory agencies going crazy. Okay, King, you are a blue collar worker. I would pipe the fuck down because half of your fucking paycheck is due to half those regulatory agencies. God bless.
I'm on your side, folks.
But absolutely, right? No one in their right mind, especially not judges or the Supreme Court, until I'm not even, every time I say Supreme Court, just assume I'm not talking about this one because I'm talking about the good ones. The Supreme Court, no one in their right mind or the Supreme Court has ever assumed that this suddenly means that regulatory agencies should just be able to go off the rails and interpret congressional statutes and action and authority as far as they want. Of course not. People don't take the time to read anything, even the most dumbed down explanation of what Chevron is, and so I will. What happens if someone sues over a regulatory agency action? Name one. It could be one of those. EPA, NLRB, okay, anyone.
I got an example.
FDA.
So OSHA passes a rule about heat safety. OSHA says you have to keep your warehouse a certain temperature.
Right.
That's it. Well, you, big business, say, I don't like this rule. I think it's overburdensome. Fine. You can sue.
Right. You
and
sue,
challenge that rule.
And under Chevron for the last 40 years, the way that Chevron would work is first, the court would decide whether Congress has spoken to this issue, whatever issue they are arguing about. So if it is an overreach of their authority, then what the court does is say, okay, what text are we looking at to find where their authority lies? And what in response, right?
Using the OSHA heat example,
in their defense, OSHA would say, look, this line of this statute, right? Section whatever and section whatever passed in this year is the authority that we're pulling from. And it could be hyper specific. It could quite literally say in a congressional statute, I mean, these are hundreds of pages of long, okay? It's very convoluted, all these statutes. It could be 2 lines that basically says, we, the power invested in Congress, give OSHA the ability to make, and they list basically exactly the heat and protection, right?
They'll say they can
reasonable
and necessary.
Reasonable and necessary restrictions, regulations based on, and then they'll list a bunch of topics. Sometimes they'll specifically say like heat protection, temperature, all of that, workplace safety, okay? Sometimes it'll be more broad. It'll just be, hey, you gotta enforce, okay, workers' rights, protect safety, health, and welfare of them, and however you think is a reasonable way to do it, period. And that's all they have to go off of, which of course, right, could absolutely lead to OSHA going off the goddamn rails and like saying that they need to now install cameras in every toilet to make sure that everyone's peeing at a normal rate.
Would that be reasonable and necessary?
See, that's where the judges come in and they say, hi, where has Congress spoken on this specific issue? If they have, then no agency interpretation outside of that specific issue they even accept. If the agency did something that is outside of the power that is specifically written in the statute, then the court goes, okay, we're done here. Wrong, rejected, bye, goodbye. But if the power that they're going off of or the statute that they're going off of is ambiguous, clearly ambiguous or vague or broad, just like, hey, anything reasonable to make sure workers are protected, period. Okay, kings and queens of Congress, what the fuck does that mean? OSHA, of course, has to still do its job. So what OSHA argues and what the court decides is whether What they did is one reasonable interpretation of that statute. And what reasonable means can mean 100 different things. There can be things that some people would find unreasonable, but objectively, with what OSHA puts on as evidence, the considerations of scientific evidence, expert opinions, testimony, all of that, they put on all of that. The court looks at all of it and says, yes, one reasonable interpretation of enforcing and implementing workplace protections would be to enact safety regulations that monitor the heat of a workplace, the temperature of a workplace, and health-related issues related to that. And they look at it specifically under a microscope, fine-tooth comb. That is Chevron. And if they found that it's reasonable, then it's good because again, the agency is tasked with hoping, right, to do reasonable things, but the court will decide, okay, was that one reasonable? You can put on evidence. That's fine.
There is a check
right?
here.
There's a check. There's absolutely a check. And
but we're deferring to the industry expertise.
Right. Because Chevron ultimately said, hey, if there's a question, we should defer to the experts, to the agencies, to the scientists who are tasked with this. And also, in deferring to the agency, you are not in the same vein saying, fuck you to Congress. You are deferring to congressional intent to make that shit vague. It is their choice to make it vague. It is their choice to be ambiguous. And the judge does not make rules. The judge is not supposed to rewrite a statute in that sense. They can make judge-made law on the side, but if a statute is implicated, they're not allowed to rewrite it. And I remember arguing this. I argued for the EPA in a moot court competition when I was a third year in law school. We won. Thank you so much. The final was before the Solicitor General of the United States, who was Noel Francisco under Trump at that time, okay? His job was quite literally to argue on behalf of the fucking government. Like, literally, that was his fucking job. So I had his fucking job, and I was supposed to argue to him, and he railed right? And it was literally like the entire time he's railing, but the facts of the case in moot court were fake, fine. But all of these laws that I was obviously memorizing, learning to spew out in this argument for this fake case we're just so, like, the whole time I'm like, people are mad about this? Like, this is as long as it's one reasonable interpretation, of course, we don't want them to over-exercise their power, but, we want to make sure that things are logical here and things make sense. Because if you have politicians in the seat or judges in the seat, in the front seat, instead of just, the driver's seat, right? If you have politicians and judges in the driver's seat, as opposed to just the front seat driver going, maybe turn left a little bit, then things are going to go askew and wrong and bad. And I'm tired of seeing cases where we only realize shit's fucked up when someone dies or people get an entire, area of law is fucked up or a bunch of people are hurt and injured irreparably before we go, maybe we should reinstate Chevron, right? Maybe we should not do that or whatever.
Yeah, I'm really glad you bring that up, Reb, because I bring up the OSHA heat rule for a specific reason. It's because I have a lot of right-wing oriented people in my family, so I hear the talking points. Oh my God.
You're fine. Just restart your thought.
Full disclosure, I donated to Kamala Harris.
Oh my God.
And they called me and texted me every day. But
that's
honestly,
tough.
It's a small price to pay. We're going to talk about why I donated to Kamala in a minute.
Okay.
Because there was a really big reason why.
Okay, amazing.
And it was a lot.
That she's
because
not
I had a big reason to donate to her. But no, talking about here's why Chevron matters to me as a workers' rights advocate. Whether you are blue collar, white collar, diehard Trumper, Republican, you could be listening to this with a red hat on your head right now. Believe it or not, I want you to have a better life. We have differences, and I really don't like your guy, and I don't like your hat, but at the end of the day, I want you to get paid a fair wage for a fair day of work, and I want you to come home alive. As a former firefighter, blue collar worker, I understand how important coming home in one piece is and how hard it can be sometimes. And that's why I like OSHA. Now, here's the thing. Congress gave OSHA the authority to make rules reasonable and necessary to promote a healthful workplace. That's intentionally vague because there's a million different industries out there. What's reasonable and necessary in an office is very different than what's reasonable and necessary in a lumber mill. OSHA is proposing what would be the first national heat safety rule. This is so important because there are only 5 states that have rules to keep you safe from excessive heat exposure. And heat will kill you. There are 2 states who have actually done something truly remarkable. They have banned heat safety protections in their state. They have banned local governments from enacting any rule that protects you from heat exposure. That's Florida and Texas, the ones you probably guessed. Now, what OSHA has done is they have taken their broad authority from Congress and they're saying, we have identified a hazard. Before OSHA can make a rule, they must identify a hazard. They used science and statistics and found, yes, excessive exposure to heat, be it in a warehouse, manufacturing, even outdoors, it can cause serious health issues for people. So because we've identified a hazard, we are now empowered by Congress to enact a rule that's reasonable and necessary to mitigate this hazard. Now, they don't get to just wave a magic wand and make whatever tyrannical rule they want to do to ruin your life. That's not what they do.
And off of that as well, to be able to come home in one piece, whether you're a blue collar worker or not, right? Whether you're just in a regular office or in a lumber yard, it should be something that you can rely upon in some kind of stable way. And the federal government, these federal agencies are not there to be tyrannical. They're there to set the minimum standard for what you can rely on as a worker to know that you have, regardless of what happens in your state, regardless of who is elected, regardless of whose money is being lined by what pocket, right? You are able to rely on the federal minimum wage, no matter what your state says. California's minimum wage is much higher. But if you're in a state that doesn't have a higher minimum wage, it's going to be $7.25. It hasn't raised in the last 15 years.
$7.25 an hour?
Kill me.
Unless you're a tipped worker, then it's $2.13.
Exactly.
Yeah.
But, right, that's just an example of you at the very least know that the bar can't get lower than that. What these federal agencies, these regulatory agencies do, and that what obviously politicians that, and I don't even want to say, conservative, because I think the word conservative has become so bastardized, of course, but I think that people who are the alt-right politicians right now in office, who are being paid by companies who don't want to pay the extra, $100 a day to be able to comply with regulations because their CEO wants a raise of $3 million, they're paying the politicians to convince you guys that regulatory agencies are tyrannical, that they're the ones coming in and stealing money from small businesses and shutting these places down, Oh, we need small government back. This isn't small government, babes, okay? The reversal of them being able to do their job is the equivalent of anarchy and chaos, which is what we came out of after Animal Farm.
With a touch of autocracy.
Right, the Industrial Revolution, when child work, right? We had child labor and kids with small hands sticking their hands into metal machines and getting their arms sawed off. We learned about it in history class.
A time before OSHA and before the NLRB. A time before OSHA.
Why do you think, that's the thing, is that we have such short-term memory loss when we get, when we are issue voters that get angry, because nothing brings people together like anger. Like a group anger, like something to hate. And we forget that, everything, if we destroyed everything we built up because of the horror that we saw in workplace conditions 100 years ago, right? And 100 years ago, we'd be like, absolutely, thank God, right? Oh my God, finally we did something. And then 100 years later, we have short-term memory loss. We forget about people who died of heat stroke every day and nothing happened about it. We forget about people who got their arms cut off. We get about
triangle shirtwaist.
Right, we forget.
People burned alive in their factory.
And the company's saying, well, it's not my problem, right? It's not my problem. If we, have short-term memory loss and we forget about all of that, then people will start not coming home. And then we'll start remembering, and then all of these protections will be put back into a place because we'll say, oh, we forgot, and the cycle will continue. Right now is the tipping point for when I just want to scream and say, so we don't need to do that, right? We don't need to have this whole, get me off this ride, right? Get me off this fucking ride. Can we just do a straight shot? Okay, toward reasonableness. Of course, every regulatory agency isn't going to do the right thing, but at least there was a check. And the courts were the check and balance. But right now, what the courts basically did, what the Supreme Court did, is say, so we're going to be the authority. Because they say now, because Chevron's gone, that Loper Bright, gives all of the authority to the court to determine whether something's reasonable without essentially taking into account an agency decision or an agency's
That sounds like big government. That sounds like one unelected person. Y'all didn't want unelected bureaucrats. At least they had degrees in the field they were regulating.
Oh.
Now you will have, and by the way, the nominal defendant in Chevron v. Natural Resource Defense Council was actually Justice Gorsuch's mom.
We can get to that when we talk about court reform and talking about recusal. We can talk about recusal.
We can talk about recusal.
Oh my God.
So I just want to be clear that I understand, as a responsible gun owner myself, I understand that there is this talking point that all these federal agencies are trying to take away your rights and make you a felon overnight. Listen,
judges will do that faster.
And a judge will do that so much faster. And what you've done is you've taken away the administrative law component, or at least you've dealt a serious blow to it. And at least in the ATF, you had people that knew the difference between a clip and a magazine. You can get in front of a judge who doesn't know anything, and they decide that your gun is dangerous. So, I understand the frustration with bureaucracy. I understand the frustration with some rules that agencies make. I don't like the DMV. I think the DMV is ridiculous. But do you know what? Better to have it than to not have it.
And the recent Supreme Court case in this term about the bump stocks. I mean, their footnotes were a mess. If you are a responsible gun owner or have ever been around weapons in your life, you'd read that opinion and go, yeah, they're bubbling through this because they don't know enough about what they're talking about, and also contradicting themselves. That's also the problem with the Supreme Court, is that their prior decisions on gun rights, gun laws, all of a sudden, I think it was Rahimi, right? Where now people are pointing out all of these inconsistencies with what they're saying because they're getting the terminology wrong and they're getting the descriptions wrong.
I'm so glad you brought that up. Reb, what is the difference? Because our Supreme Court Justice Neil Gorsuch, who wrote this opinion, doesn't know. So I want to know if you know, because I don't know.
Is it the laughing gas?
What is the difference between nitrous oxide and nitrogen dioxide? Because the Supreme Court justices don't know. Yet they made a rule on these gases that they don't know.
Yes.
What is the difference?
So one of them is laughing gas, like for getting your wisdom teeth out or whatnot. The other one is a pollutant in the air that the EPA, the Clean Air Act, regulates. I think that's the answer.
Wouldn't it be great if we had scientists with years of professional training and experience to say what levels of which chemical are safe to be expelled from a factory?
Right, but unfortunately, Gorsuch, in his opinion on the pollutant, he cited he said the laughing gas the entire time. And just to give you an idea,
if not so terrifying.
Right. It would be fun. And that's why Loper-Bright taking away the ability for it to be established precedent in law for the last 40 years for agencies to be able to be deferred to and of what is reasonable and what isn't, to a degree, to an extent, is so awful. And honestly, Kagan's dissent, and I'm just going to read just this part so people can understand it.
Go off, Reb.
She is brilliant. She said, today, the court flips the script. It is now the courts rather than the agency that will wield power when Congress has left an area of interpretive discretion. A rule of judicial humility gives way to a rule of judicial hubris. In recent years, this court has too often taken for itself decision-making authority Congress assigned to agencies. Doesn't that seem like big government to you? One branch of it, for sure. The court has substituted its own judgment on workplace health for that of the Occupational Safety and Health Administration, OSHA, its own judgment on climate change for that of the EPA, and its own judgment on student loans for that of the Department of Education. But evidently that was, for this court, all too piecemeal. In one fell swoop in Loper-Bright, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. It has become the country's administrative czar, even though nowhere in the Constitution or in a rational mind did anyone give them the power to be the regulatory enforcement body, executive power. They're now, if anything, the legislative branch too, because they're going to be telling everyone what Congress's statutes mean, but not with any other commentary, expert commentary, regulation commentary. No, they're just going to say, I think that sounds like laughing gas to me.
Yeah.
And what's the problem with it too is that this case, and Justice Kagan comments on this a lot, because Chevron has been established law for 40 years in such a way that every case after it has depended upon it and has pulled from it. Every regulation, every single regulation and statute that has employed an administrative body, which is most of them, has been written, has been interpreted, has been enforced with Chevron in mind, meaning that the agencies have not I mean, Chevron, it's not even just the word Chevron, obviously. That's not what I mean. I mean that the idea that the agency will be deferred to has been written into the policies, has been written into our lives, into our world. That is the fallback. That's the stability that we have. We've built this structure of stare decisis, of precedent that we can fall back on. And Kagan points out that, yes, there are so many cases, Supreme Court cases, that may be ripe for overturning. They may be wrong. They may have been wrong, right? And then a case comes up and we realize it was wrong. This isn't one of them. Chevron deserved to be entitled to stare decisis, to be entitled to that 40 years of judge after judge, of justice after justice saying, yes, this is right. You cannot, with 6 people, decide that all of that is wrong. And I'm not even going to get into, because people will say, well, wasn't it unconstitutional? Well, no. So no. No. They're like,
every justice before them didn't think so.
The administration procedural act said that's not okay. So yeah, so Kagan basically does the equivalent of just a drag by the hair her entire dissent to this opinion, and basically points out every single way that the majority's analysis is just wrong. It's just plain wrong. They cherry pick what they want to be from the history, from precedent, from law, from the Constitution,
from the Federalist Papers,
right? From the Federalist Papers, what they basically cherry pick. They cherry pick whatever they want to rationalize the outcome they want, because they only want the outcome. They don't give a fuck about how they get there. And then they also say, oh yeah, by the way, none of the other cases that relied on Chevron are going to be overturned. But like now you don't have Chevron. See you next time. So what that means is not necessarily that every regulation is suddenly gone. It's that every single time, right? Basically, the courts are going to be overrun by people challenging every single administrative, people. When I say people,
I mean, tell you what I think is going to happen, Reb?
Yeah, tell me.
I think the Fifth Circuit specifically.
God bless those motherfuckers.
The Fifth Circuit specifically is going to see a bunch of new LLCs get formed. Just weird. How weird. All these small business, all these LLCs are going to get formed. And every single one of them is going to challenge a different federal regulation from an agency. Everything. Folks, these are the stakes. Right now, you have the right to look over to your coworker and say, hey, man, how much are they paying you? Congress never gave you that right. Congress empowered the National Labor Relations Board to figure out what they meant by saying you are safe to engage in concerted activities with your coworkers. That's the language of the statute. That is ambiguous. And the National Labor Relations Board said, you know what? Asking your coworkers how much they make to make sure you're getting paid fairly sounds reasonable and necessary. Hey, there's that language again.
Yep,
there we go.
Absolutely.
Bringing it all back, folks.
And the reason why, too, people always say, like you said, well, Congress now has to do their job and write specific statutes. They do this. Sometimes it's just sloppy, but most of the time, Congress intentionally writes ambiguities and vagueness into statutes, not because they want to somehow be horrible and to throw everything, up to chance. They do that because they don't want statutes that last for 6 months. They want statutes that are going to last, like the Clean Air Act, for 40 fucking years. They don't want to have to rewrite that thing every time a new pollutant comes into the air, every time a new, social media pops up. How does that impact workplace policy? Well, OSHA was created before, Twitter was going on. So, I mean, we're going to have to wait to do anything about the fact that people are texting each other or tweeting about how much they're paid or, engaging in acts which, promote their own workplace, whatever. Yeah, we're going to have to wait to do anything about that or just say that that's okay until Congress specifically says that Twitter, you are allowed to use it, or social media or texting, you are allowed to use it to share how much you're paid. Do you see why that's so asinine? They write vague laws because they want laws to withstand the erosion of time and also be able to hold up against, progressive movements or just the society changing as we see it, things happening, technology happening. The way that agencies interpret vague statutes is supposed to be obviously reasonable. They have a check on that. They used to, but they do it not because they're trying to enforce more power. They're trying to give you more power.
It is proactive, too. We don't have to wait for Congress, which, by the way, this last congressional
forever
section,
and is stupid and it's all political. They don't do shit. I'm sorry. They don't
It was one of the least productive in U.S. history. And that's a problem because if you're trying to answer the question you raised, can social media be used between coworkers to talk about pay and work conditions? The answer is an unequivocal yes.
Yes.
Because we had agencies already anticipate that. And we don't have to wait for Congress to come over and get some bipartisan resolution. And so I brought up earlier the Fifth Circuit and why I think a bunch of LLCs are going to be formed there. I want to be very clear. It's not because the Fifth Circuit is so conservative and Republican and small government that lots of business will happen there. No. Those LLCs are bullshit. What happens is agencies like the Heritage Foundation that's been making some news, they will start a business in a district that they know they will have favorable judgments in. So if they want to challenge something like your right to discuss your pay at work, they will found an LLC in fucking Georgia or wherever, challenge the NLRB's authority. Now, normally that challenge is dead in the water, donezo, it's not going anywhere. But now with Chevron deference overturned, we're now in limbo. We're in uncharted territory. Mm-hmm. We have stability, predictability, and rules that have been in place since before I've been alive. Suddenly they're not there anymore. So if Business LLC, which was founded, I don't know, June of 2024 and has one employee, challenges that rule, well, now there is a real risk that LLC can make its way up the Fifth Circuit or into the Supreme Court and get a ruling from them saying, you know what? Not only can you not discuss pay and work conditions at work, but we don't think the NLRB should even exist. We think it was a congressional overreach.
And what kills me is when the second richest person in the world is bitching about workplace regulations and policy. Why in the frick-frack paddywhack do you think, as a regular worker on the floor of these factories, you think, yeah, small government, what they want, I'm going to pause it, is not going to be what anyone else wants. It's going to be what makes their lives easier, which, to be honest, when you're running a business, I don't want your life to be easier when it comes to workplace safety, when it comes to health, when it comes to their pay. It should be easier for you to, I don't know, sell things that are ethically produced and ethically made and that you paid people properly for. Sure. If you do everything right, it's pretty easy. But like anyone massively profiting from any Supreme Court decision, whatever they're supporting, I'm going to side eye regardless. I don't care if you donate to charities. You're probably donating to a politician too. And at this point, you're probably donating to fucking Supreme Court justice because we don't really care anymore if they're corrupt as hell.
What was it, $4 million that we know of?
I wouldn't be
for
surprised.
justice, hashtag Sugar Baby Thomas. I've been trying to make that trend forever.
I call Justice Alito Mosquito.
Nice.
Because I'm like, yeah, Mosquito and Alito, or Mosquito and Thomas.
Yeah, that's what he gets. It's scary times right now. I don't like it. I think the way we push back, this is my theory, Reb, I want to know what you think, is we need to undo a little bit of the misinformation. I get it. Here goes liberal attorney Ryan again. I don't like him because he's a Democrat, whatever. Look, I don't care if you're a Republican. I truly want you to have a better life because secretly my evil plan, here's my evil plan, is for your life to get better. And then when your life gets better, you're less angry. And when you're less angry, we don't have dumb Hitler running for president anymore. When you're less angry, my family can feel safe in their marriages. When you're less angry, immigrants can come to this country legally, quickly, and get a job and live the American dream. Because the truth is, your anger is sending us back many decades. So my evil plan is to protect OSHA and protect the NLRB so you can make more money and be safe at work so that you look around and realize, you know what, I'm not angry. Mm-hmm. And maybe I'm not looking for a scapegoat all the time. And maybe it'll be a little harder for some billionaire dickhead to say, oh, that darn Department of Labor, they're making your life worse. Mm-hmm. No, they are not.
And you know, the Republicans like to, I mean, not all Republicans, but a lot of the alt-right ones like to just, you know, point at every policy that they see as liberal and just call it socialism. This is socialism, this, socialism, that. It's not socialism. We want to build schools. We want to build roads. We want to pay people what they should be paid. There are things in a capitalist society that we have, American dream freedom that we have to be done in a community-centered, community-forward aspect. It's not every man for himself. It cannot be. It's not socialism to make sure that the person next to you has the disability, regulations that are put in place so that they are treated fairly.
Teamwork isn't socialism.
Right, teamwork is not socialism. Helping your neighbor isn't socialism. And seeing people who are different than you, who work different jobs than you, right? I don't see a blue collar worker as an attorney as, someone I need to fight. I see them as my neighbor, and I want them to have the protections that they have, the same way that I have protections in my workplace, the same way that I, am not discriminated against in certain respects. Thank God. God bless. I still am in this field because it is the legal field, but we're getting fucking there. We're fucking getting there.
Oh my God.
But right, like of course, the politicians who are being paid by the PACs, by the Elon Musks, by the big companies, the Jeff Bezos, of course they are going to try to convince you that everything that is pushed that protects people is socialism, which is, a buzzword. It's oh no, this can't possibly be good, right? Oh, well, I want to work, right? Not everyone should get a piece of the pie if they're not working for it. So yeah, what they just called socialism is like whatever the law they're talking about, was actually going to like raise your wage by $20, but go, right? But whatever.
I like, not everything is socialism.
No.
And I understand freedom, capitalism, free markets. I'm for that. I'm a for-profit business owner.
You can pull yourself up.
Yeah.
We are a pull yourself up by your bootstrap society. Yeah. But what happens when you don't have boots? We have to give people the protections and the rights afforded to just humans. Honest to God, there has to be empathy in our law. And if you don't think there should be, then you are going to be the one who suffers for it. You are. Well, you're not going to win.
Well, you know what? I think that's a really good way to wrap up some of these thoughts here. We didn't get to Trump v. United States today. Hopefully we can talk about that again. I don't know if my blood pressure can handle it, to be totally honest.
Look, I did a very long, detailed video on it.
Oh, was that on your YouTube?
Yeah, on my TikTok page. So,
was that the 10-minute long one?
Yeah. So okay.
I listened to it twice.
Amazing, incredible. Yeah. No, I if you would, and this is not even just a plug, but if you would like an explanation on what exactly Trump v. US was, or even more information on Chevron, there are videos on my page that are recent from July where I just kind of break it down.
And where can people find that? What's your
on
handles?
My TikTok page at Reb Masel, on my Instagram at Reb Masel, on my Twitter at Reb Masel, on my podcast at Rebuttal Podcast, and in the comment sections of trolls.
I absolutely love it. We're out of time, but
amazing.
Reb, thank you so much for coming on.
Thank you for having me.
Always love having you here. That's it.
I can't take no loss. I don't even know what it costs.